Welcome to Inventiveminds Child, Youth, and Family Support Center. We are a not-for-profit organization working with families in their day-to-day parenting by providing workshops and seminars related to pediatric and child development. Inventiveminds provides care in the early years sectors for newborn to age 6, licensed under the Ministry of Education all across Ontario. Inventiveminds carries an elementary school open to international students from junior kindergarten to grade 3. The Inventiveminds Family Center helps families in mediation, arbitration, and parent coordination cases related to family separation and divorce. We support families during and past separation and divorce. Inventiveminds works with court orders to conduct child voice report and parenting courses related to CAS, court, and mediation purposes. To learn more about our services, reach us at inventivekidz.com.
Thank you for joining this Inventiveminds Child, Youth, and Family Support Center workshop hosted by me, Adam Staviss, your youth development mentoring coach. Today's workshop topic is entitled Legal Rights in a Common Law Relationship. Today, we have with us Rose Morsch.
Thank you, Adam.
For those of you that don't know, Rose has experience of over 20 years in child development and a bachelor's in child development. Rose is an RECE, holds designations that qualify her in child voice and child inclusivity. Rose is also a parent practitioner and family mediator. She specializes in working with infancy to teens and is the director of operations for Inventiveminds Child, Youth, and Family Support Center. Anything in particular, Rose, that you would like to go through first in relation to today's topic, or do you want to just begin with defining what a common law relationship is?
Well, before we start, I want to take a moment and acknowledge that I realize anyone who's listening to this today or in future or who's joined us today, I realize this is a very emotional time for everyone. These topics are not anybody's favorite topic, and we want to let you know that we respect that space that you're in. Take it day by day. When you're feeling high emotions, do not react. Take a step back. Take lots of breathing, and maybe sometimes reflect to it after.
Yeah, really good to keep in mind. Like if you start to notice that your emotions are racing a little bit, take a step back, try to do something a little bit different. It's better to take a moment to process things rather than being kind of reactive. Easier said than done, but that is certainly something to keep in mind. Let's start by defining a common law relationship, what a common law relationship exactly is.
If you look at this common law concept, has changed so much over decades and decades. So it's something that it should always be revisited to look at what the new bylaws with it under Family Law Act or any civil law act carries when it comes to common law relationship. At this point, it is generally when two people make a life together without being married. These two people are considered common law partners if they have been continuously living together for at least 3 years. But in cases where they have a child together or where they have adopted a child together or there's another circumstances around it, normally it could be 6 months to a year. It has really been divided based on categories and the circumstances and situation around it.
Right. So as soon as children are involved, it changes things quite dramatically. We should also mention that because sometimes we get people that are listening in from various parts of the world, not just necessarily where we are at. So this is in relation to
Ontario, Canada. Yes.
Ontario, Canada. We should specify.
Again, the legislation with common law or any divorce, sometimes it's very different per provinces. Some of the things we're talking about it does not even relate to Quebec. So really, the minute that there's a child involved, doesn't even need to be a year.
Maybe we could expand on how child support works in a common law relationship, because if there's a relationship breakdown, that's something that would have to be considered, correct?
Yeah, so with the child support in common law relationship, it really depends based on the parenting schedule that is first created. And that parenting schedule can really vary per age of the child and the milestone of the child. Plan that is made between both parties. If it's 50-50, it's very different than if it's 60-40. If there are overnights or there aren't overnights. So really, the whole picture varies based on the parenting schedule, really, that is in place. But the table amount is based on the gross annual income of the payer parent and the number of the children they have to support. Please keep in mind, as I said, that all varies as well. There has to be a parenting schedule in place in order to look at the child support. The child support continues until the child is 18 for both parties. It could go up to 16 if the child moves out. And it can also continue longer than when a child is 18 if there's some form of exceptional need. It's like really a lifetime commitment.
That's always been my sentiment. Like, with that in mind, it makes me wonder, is it common to come up with these sort of parenting plans when relationships break down, or is it kind of advisable to think about that beforehand?
You know what? A lot of couples these days, even if you are common law, you can have a cohabitation agreement. In your cohabitation agreement, you can specify parenting in there if that's something you want to do, because you're having an open communication about it before getting into it. But really, how many percent of us think about that? You might have one type of parenting style, and then the other parent might have another parenting style. And this is the mentality you both had, but when the reality comes in and you're acting it out, might be very different. So hopefully we're hoping for people to grow together so they can have common grounds and values and beliefs when it comes to raising their children. But unfortunately, when we're talking about topics like this, there has been that breakdown. The beliefs are not the same. There might be things that are different. In our parenting plan, we look at the common interests of parents and we built on that to help creating a schedule, and we are looking at the child's best interest. And as the child gets older, you want to get the child voice in there. As early as 7 years old, you can have a child voice into the parenting plan and schedule, because you might want to do something, your partner want to do something, but really, what's the best benefit of the child? I guess child support is one of those topics that can change all the time based on the needs of the child and the income of the two partners.
And that's why these get reviewed again.
Well, for the financial part, it is recommended annually. With the schedule, again, it really depends on the child's development and milestone. Overall, there's a specific calculation that is done in Ontario. Technically, both parents are responsible to pay for the child. They look at the gross income, and based on that is calculated.
All right. Of course, in a common law relationship, spousal support is something that someone may be entitled to receive, I imagine, but perhaps you can just give us a little more information on those circumstances. So
in Ontario, common laws have the same inputs to spousal support as married couples, as long as they have been living together for at least 3 years, or if they have a child together. Again, when the topic of child comes in, everything becomes totally different. The amount of support ranges from 1.5 to 2% of the difference between the spouse's gross income amounts for each year of marriage or cohabitation, up to a maximum of 50%.
50%?
Yeah. And the duration of it, all of that varies. Again, it's something that you can give a general overview, but in each case, it's very different. So when you go through mediation/arbitration, mediation is when both parties are sitting together, they're able to communicate effectively, make certain decisions together, where the arbitration, when it comes in place, is when you're not able to agree in certain topics, and then the arbitrator awards the situation, looking at both parties' documents and makes an award based on information and things.
Right. It's very case by case.
When it comes to spousal support, yes, common law people are entitled to it. Depends into the duration of the relationship and if there's a child.
We started to get into this a little bit. In the event of a separation or relationship breakdown, are there typically equalization formula that's calculated, or kind of just split 50-50, you pick, I pick scenario? How is that sorted out?
Under the common law relationship in Ontario, when it comes to asset equalization and property, obviously, if you have rented a property, it falls under Civil Law Act. Whoever has the rental agreement in written is the one who can stay in that home. The other partner can leave. There is no asset in there. Generally, common law couples do not have the right to split an increase in value of the property they brought with them in the relationship. If you contributed to property your partner owns, you may have a right to part of it, like what you said, unless the ex agrees to pay you back. For most common law relationships who jointly own real estate or other substantial asset, they will in fact be split 50-50. Again, it's case by case, so it needs to be really reviewed, and certain laws are looked into places. And there's so many things involved with it. It's not like before. In fact, it is not really a legal dispute to take one's own property when a relationship ends.
Right.
Overall, the Ontario Family Law Act, that we call FLA, governs the division of property apply only to married couples, not to common law couples. Each partner in common law relationship is therefore entitled only to whatever he or she brought into the relationship or acquired during it, if that makes sense to you.
Right. Yeah, that makes perfect sense. Okay, fair enough. Now, we talked about parenting plans. I mean, do you absolutely have to do these? Separation agreements, parenting plans, these sorts of things. Is there circumstances where they're not done, they're not needed? Or is it like 100% of the time you've got to go through a parenting plan? If you've got a child, you have to go through a separation agreement if there's a relationship breakdown?
It is highly recommended that you do have a parenting plan, a parenting schedule. It's like a separation agreement. You want to have it even as a common law couple. There will be disputes, there will be conflicts, and this is giving you guys boundaries in your relationship, okay?
Right.
And it's bringing some form of stability for the child and for both of you to move forward. Again, a relationship may have been broken, but there is a relationship to continue for the best interest of the child. And I think that's really the key point here to understand. The information we provided today is quite general information. If you've been in a common law relationship for 20 years, there's a huge difference in being in a common law relationship in 6 months.
For sure.
There's just so many little things that are there. But the good thing about common law is the law has changed so much over the decades. And it's one of those laws that continuously will change and evolve.
The main goal for people to put together a parenting plan and a separation agreement, from my perspective, you'll correct me if I'm wrong, is to really outline how things will be done moving forward as a relationship is dissolving. What will that look like? How will that dissolving of the relationship be helpful for both people to move on as well as they can, considering that it's difficult circumstances? It's to kind of avoid any sort of scenarios where that could escalate potentially.
Also, if, for example, one parent stopped making payment, you want to have that in place so you can take active role on it, or introducing new partners into the relationship, how you want to parent together, religious belief, educational belief, major decision making. There's so much involvement when there's a child.
And seeking a professional on it that has seen so many different circumstances come up between people. They kind of have a checklist of items to go through, to consider, to think about, to create conversations around that couples may not be thinking of so much. It's really about taking measures to prevent things going down a road that will complicate your life. Yeah.
Exactly. And if you do these through mediation and arbitration, you're arm and a leg ahead, because you're not moving to litigation where you each have to get your own representatives and begin an argument, which litigation means you're in a battlefield with each other, right?
Sure.
So instead of resolving the high conflicts, you're just adding on fire to the high conflict. So it just never sort of ends.
100%.
Where, if your partner is highly emotional and you're going to be highly emotional, nothing's going to get solved. You're going to be emotional. How can you not be emotional? It's the most intense time of your life, right?
For sure.
So the best suggestion is always take a step back. Don't even look at the messages or the emails for the day or for 48 hours, and sometimes read it 2 or 3 times before replying back, because each time when you read a message coming in, you yourself will notice you take the message differently. But
Sure.
if you read it then and you act on it then, or you hear the voice message on your answering machine, you act on it then, you're just adding on to the situation, diffusing some of that. And that's what mediation does. That's what it helps you to do. It's not therapy. It's just giving you ways of resolving the conflicts that exist and coming up with a plan that is effective for the kids and for you guys, because it's really about your communication together and resolving the conflicts that are there.
100%. Yeah. I'm in many situations all the time where there's certain individuals that I have to interact with and my blood will start boiling. So if you're in a situation where it's with this relationship that's dissolving and your blood starts boiling, what I do is I will write out the entire thing I want to say in the moment, but I won't send it. Look back at it and I'll ask myself, do I really want to send this? I might consult somebody who can think a little more objectively. to ask what their thoughts are. Like, should I really be sending this message? Is this going to make things more difficult potentially? It's a balance too, because sometimes not responding can also escalate something too. It's a really delicate balance between like responding within enough time. Like sometimes even what I'll do is like, so I'll say, okay, I received your message, give me some time and I will get back to you.
It's like picking and choosing what you want to allow it to become a high conflict, right?
For sure.
In one of the parenting plan, it was that a parent is to bring the child hockey stick back to the house because the other parent had purchased the hockey stick and the parent had paid for the course, for the sport. So the other parent decides to take those hockey sticks and throw them in the backyard.
Right.
So what are we going to do in that situation? That was something that Ashley had to end up going the parenting plan to discuss how the hockey stick is to be delivered. So each situation for each home is very different. It needs to be respected. And sometimes we need to put boundaries. So if your boundary is, I'm not going to answer to this right now because it's not related to emergency 911, my child's safety. I can reflect to this after. You can do that. And
again, if your blood is boiling, just simply saying like, got your message, give me a day and I will give you a proper response.
And sometimes you notice that individuals, they do mediation, arbitration, and there's just too much of a conflict where they actually need a parent coordinator. And that's where they're coming. So they help with the parenting and the communication between the two individuals, where they actually have the legal right of coming up with awards, which is making the decisions that it is acceptable in court of law. And that's something we also provide at Inventiveminds.
Oh, nice. Okay, good to be able to make that specification. Okay, I know we're starting to run out on time here, so maybe just last question. Should somebody be considering trying to put together some sort of agreement on their own, or is it much more recommended to get a professional to do it for you?
Obviously, professional is what we recommend because as you talked about the whole checklist, we do have a checklist, although the mediation report is something that it's based on what the two parties agreed upon that goes in there. But having the opportunity doing a mediation/arbitration gives the opportunity to ensure all topics are touched and talked and are placed in the agreement. So that way, if there's areas with child support or spousal support or concern with asset, it's all being reviewed professionally with full understanding, because there might be many other asset things that needs to be referred to that you are not aware of and you are not aware of your rights. So going through mediation/arbitration or /just mediation really helps putting all of this together in a professional way so you can move forward.
And help you make sure you're not missing anything, or help you make sure that you're thinking of all the things that you should be thinking about and having all the appropriate conversations. Okay, very good.
Please feel free to reach out to InventiveKidz.com and look at our other events and workshops coming up in our family center. Have a wonderful day, everyone. Take care.